So the owner has three choices on who will do the construction works. 1, he might do the work himself. 2, he might select a construction consultant who is also a builder. And 3, he might choose a construction contractor. In competitive bidding, this means a construction project is built by a contractor who has competed with others for the job. The owner chooses the contractor by comparing what several contractors say it would cost them to do the job. The owner makes contract with the one who has said he can do the job correctly for the least amount of money or lowest bidder. A contract is an agreement enforceable at law made between two parties. In simple terms, construction contracts are legally binding agreement that explain the work to be performed by a general contractor and also the payment. Both play a very important role in construction management. The following list shows us some reasons why we need contract, especially in the construction field. 1, it describes the scope of work. It establishes the time frame, cost and payment provisions. It set forth the obligations. It minimizes the disputes and helps improve economic return of investment. Construction projects vary greatly in terms of complexity and size, so there's not a one size fits all approach when it comes to construction contracts. That's why several types of construction contracts have been developed over time, such as schedule of rate contract, lump sum, and the cost plus contract or the CPC. Schedule of rate contracts or SRC, these are, for example, contractor offers to carry at various clearly defined classes of work at stipulated unit rates. The work to be done is scheduled as accurately as the quantities can be estimated by the actual quantities which are measured in the completion of work and paid for at the price stated in the tender. A schedule of rates is a document that sets out the rates charged for various items of work by a contractor. The schedule can be used as basis for pricing a contract and can be used to compare the prices charged by different contractors. It may also be used to calculate the cost of a project, and SRCs are also a schedule of the work items without quantities, which is prepared by the owner and to be rated by the contractor. The description of items and the units of measurements are similar to those in a normal BOQ or bill of quantities, but there's no quantities given. It is common for separate rates to be quoted for labor and materials. SRCs are commonly used for repair and maintenance works or under conditions of urgency. Next, we have the lump sum contract. These are those in which the contract offers to do the whole of the work specified and shown in drawings for a total stipulated sum of money. In this contract, it is essential that the work is clearly defined and drawn. Although, to cover any possibility of extension or reduction of the work shown, it is to include a schedule of prices to enable such addition and deduction to be assessed. It involves a total fixed price for all construction-related activities. It can include incentives or benefits for early termination, or can also have penalties called liquidated damages for a late termination. Lump sum contracts are preferred when a clear scope and a defined schedule has been reviewed and agreed upon. Again, a lump sum contract is an agreement that sets a predetermined cost for construction work. In other words, the contractor performing the work agrees to complete the project for a fixed amount, no more or less. Notably, that contract amount is tied to all specific scope of work. So, contractors are not obligated to perform above and beyond the original agreement. With a cost plus contract, the contractor gets paid for all expenses of a project plus either an agreed upon profit, which is usually defined as percentage of the contract's total cost or a fixed fee. In short, CPC means actual cost plus a negotiated reimbursement to cover overhead and profit. The plus is part of cost plus contracts, which is usually in the range of, say, 10 to 20% of the project's total cost. The contractor must still produce an estimate instead of a fixed cost to give the owner an idea of the cost of the project. Cost plus contracts can be contrasted with fixed cost contracts, in which two parties agree upfront to a specific cost regardless of the actual expenses incurred by the contractor. Cost plus contracts may also be known as cost reimbursement contracts. Cost plus award fee contracts. This allows the contractor to be awarded a fee usually for good performance. Cost plus fixed fee contracts cover both direct and indirect cost in addition to a fixed fee. Cost plus incentive fee contracts happen when contractor is given a fee if their performance meets or exceeds expectation. Cost plus percent of cost contracts. This allows the amount of reimbursement to rise if the contractor's cost rise. Another example, cost plus percentage cost, or CPC again, has an estimated cost of 120,000 with an agreed profit of 10% of the cost. So the actual cost of the project is 130,000. What if problems arise? In case of conflicts or poor performance or poor compliance from the implementing company, termination of contract is possible. Contract termination means ending a contract for specific reasons. However, there are other causes that can also lead to contract termination. A contract is said to be discharged when the agreement between the parties is terminated and the right and liabilities arising from it are extinguished and accomplished in any of the following. We have the by agreement, by performance, by breach, by lapse of time, or by impossibility. If we say by agreement, the parties agree to terminate the contract either by one waiving his rights or by releasing the other from his obligation. By performance, in this case, there is a complete fulfillment of the terms of the contract in every aspect. If we say by breach, one party falls in his obligations and the other then has the right to cancel the contract and sue for damages. By lapse of time, an action on a simple contract which must be commenced within a certain time from the date when the cause of action arose. By impossibility, this may be due to a cause which has arisen since the making of the contract. The question is there a second chance? Can a construction contract termination letter be revoked or rescind? The answer is, in certain circumstances, a construction contract termination letter can be revoked or rescinded if both parties agree to continue the contract or if the reasons for termination are resolved. It may be possible to withdraw the termination letter. However, it is important to consult with the other party and seek legal advice to determine the feasibility and implications of revoking the termination. Construction disputes. These are the main challenges to successful construction projects. Most construction parties experience claims and even worse, disputes which are costly and time-consuming to resolve. These disputes are inevitable in construction projects which predominantly arise from complexity and magnitude of works, multiple prime contracting parties, poorly prepared or executed contract documents, inadequate planning, financial issues, and communication problems. Understanding how and why disputes happen is the first step to preventing them. In case this becomes worse, we resolve this with the help of various construction dispute resolution methods, such as we have negotiation, mediation, arbitration, and litigation or going to court. First of all, dispute is a misunderstanding between two parties, either contractual or non-contractual. This is caused by disagreements on project issues that includes factors such as we have the cost, the roles and responsibilities, project scope, project deliverables, project team selection, among any other project-related aspects such as degree of bias and culture. Disputes waste money, therefore it drains profits and destroys relationships and it takes energy away from projects. Construction delays, variations, and efficiency issues and exceeding cost can be some causes for the dispute to arise in the project. Typically, construction disputes occur between the owner and the main contractor. Also, subcontractors, and design professionals. We also have the consultant. The main source of this problem is the lack of precision in the contract description between involving parties. We have different dispute causes categorized by clients, contractors, and we also have the consultants. Under clients, disputes arise from the following instances such as deficient management supervision, lowest price mentality in engagement of contractor, poor communication, discrepancies in contract documents, failure to appoint project manager, and failure to respond in time. Under contractors, we experience delay, suspension of work, lack of understanding and agreement in contract procurement, inadequate CPM or the critical path method scheduling and update requirement, failure to plan and execute the changes of works, and reluctance to seek clarification. Lastly, we also have instances of disputes caused by the consultant such as failure to understand its responsibility under the design team contract, incompleteness of drawing and specification, design and specification oversight and errors or omission from specialists, and fifth, we have variations due to design errors. In some cases, disputes are resolved upon approval of the following changes and penalties which are not accounted to the contractor. For example, we have time extensions which are added to the original duration. This means all construction contracts allow the construction period to be extended where there are delays that are not the contractor's fault. Delays may be caused by weather conditions, strikes, pandemic, and land acquisition. However, for change order, these are modifications to the original contract documentations. For change conditions are the claims of the contractor in case the site conditions encountered are not what assumed at bid time. To claim a change condition, the contractor must prove that conditions as found on site are different from those reflected in the contract documents. especially in the civil drawings. And then we have an unknown or unusual condition encountered and not normally expected. The common cause of change conditions could be change in topographical portion in site, which affects the building contract. Then we have subsurface variation, which is more on earthworks. Then we have change in underground water table. If the owner does not accept a change condition claimed by contractor, how should this dispute be resolved? The validity of contractor's claim must be established either by arbitration or litigation. If the owner accepts the changed condition, how this condition is added to the original contract, the extended scope of work due to the changed condition will be included in the contract as a change order. Lastly, we have the LD or liquidated damages. These are the damage to the owner due to contractor overrunning the day of the project completion. The contractor pays for each day overrunning a sum equal to the sum lost by the owner. Compared to penalty, a penalty is an amount of money usually higher than the LD and estimated without any link to actual damages incurred by the owner. We are all familiar with the most traditional dispute resolution process of our civil justice system, litigation, and trial with a judge or jury deciding who is right or wrong, where someone wins and someone loses. However, there are many other options available, such as this one we have negotiation, mediation, arbitration. These three are commonly called as ADR, or the Alternative Dispute Resolution, are the most well-known. In fact, most cases that are filed in court are settled and never go to trial. Only 5% of all cases filed go to trial. ADR, these ADR procedures are excellent options for you in dealing with controversy with less expense than traditional litigation and allow you to maintain control of your legal matter. The following process describe ways to resolve disputes. First, we have negotiation. Negotiation is the basic means of settling differences. It is a back and forth communication between the parties of the conflict with the goal of trying to find a solution. The process, you may negotiate directly with the other person. You may hire an attorney to negotiate directly with the other side on your behalf. There are no specific procedures to follow. You can determine your own, but it works best if all parties agree to remain calm, not talk at the same time. You can negotiate in the boardroom of a big company, in an office, or even in your own living room. Negotiation allows you to participate directly in decisions that affect you. In the most successful negotiations, the needs of both parties are considered. A negotiated agreement can become a contract and can be enforceable. So when and how negotiation is used, most people use negotiation every day. In some circumstances, you may want a lawyer to help you to negotiate a fair deal. Negotiation is the first method of choice for problem solving and trying to reach a mutually acceptable agreement. If no agreement is reached, then you may pursue any other options. This process can be appropriately used at any stage of the conflict before a lawsuit is filed. While a lawsuit is in progress at the conclusion of a trial, even before or after an appeal is filed. Characteristics of negotiation are listed. Next, we have mediation. Mediation is the process of settling disputes with the help of a third party. or a third neutral party, which is called the mediator. Mediation is also a voluntary process in which an impartial person or the mediator helps with the communication between the parties and promotes reconciliation, which allow them to reach a mutually acceptable agreement. Mediation is often the next step if negotiation proves unsuccessful. A mediator manages the process and helps facilitate negotiation between the parties. At the beginning of the mediation session, the mediator will describe the process and ground rules. The parties or their attorneys have an opportunity to explain their view of the dispute. Mediation helps each side better understand the other's point of view or POV. Sometimes the mediator will meet separately with each side. Separate separate caucus can help address emotional and factual issues as well as they allow time for receiving a legal advice from your attorney. Mediations are generally held in office of the mediator or another agreed neutral location. If a lawsuit has been filed, the agreement is typically presented to the court as an enforceable order. If no lawsuit has been filed, the mediation agreement can become an enforceable contract. Now, if no agreement is reached, you have not lost any of your rights, and you can pursue other options such as arbitration or going to trial. When and how do we use mediation method? When you and the other person are unable to negotiate a resolution to your dispute by yourselves, you may seek the assistance of a mediator who will help you and the other party explore ways of resolving your differences. You may choose to go to mediation with or without a lawyer, depending upon the type of problem you have. Characteristics of mediation are as follows. Next, we have arbitration. Arbitration is the submission of a disputed matter to an impartial person, who is called the arbitrator for decision. The process, arbitration is typically an out-of-court method for resolving a dispute. The arbitrator controls the process, listens to both sides, and makes a decision. Like a trial, only one side will prevail. But unlike a trial, appeal rights are limited. In a formal setting, the arbitrator will conduct a hearing where all parties present evidences through documents, exhibits, and also testimony. The parties may agree to, in some instances, like establishing their own procedure or administrating organization which provides also the procedure. They can be either one arbitrator or a panel of three arbitrators. An arbitration hearing is usually held in offices or other meeting rooms. The result can be binding if all parties have previously agreed to be bound by the decision. In that case, the right to appeal the arbitrator's decision is very limited. An arbitrator's award can be reduced to judgment in a court and thus be enforceable. In non-binding arbitration, a decision may become final if all parties agree to accept it, or it may serve to help you evaluate the case and be a starting point for settlement talks. Common use arbitration is in the area of labor disputes between construction and the city in wage disputes. You will usually be represented by attorney in arbitration. Characteristics of arbitration. It can be used voluntarily. It can be private unless the limited court appeal is made. It may be less formal and structured than going to court, depending on applicable arbitration rules. It is usually quicker and less expensive than going to court, depending on applicable arbitration rules. Each party will have the opportunity to present evidence and make arguments, and each may have the right to choose an arbitrator with specialized expertise. A decision will be made by the arbitration that may resolve the dispute and be final. The difference is of mediation and arbitration. With mediation, the final decision is a reached agreement between the two conflicting parties, while arbitration calls on an arbitrator to analyze the case and reach for a verdict. Next, we have litigation or going to court. If you cannot settle your differences through ADR or the negotiation, mediation, and arbitration or some other means, you can pursue litigation through the courts with your lawyer. Litigation is the use of the courts and civil justice system to resolve legal controversies, and litigation can also be used to compel the opposing party to participate in the solution. Litigation is begun by filing a lawsuit in a court. Specific rules of procedure, discovery, and presentation of evidence must be followed. The attorney for the other side will want to take your deposition to learn more about the facts as you see them and your position in that case. There can be a number of court appearances by you and your lawyer. If the parties cannot agree on how to settle the case, either the judge or jury will decide the dispute for you through a trial. A trial is a formal judicial proceeding allowing full examination and determination of all the issues between the parties, with each side presenting its case to either a jury or a judge. The decision is made by applying the facts of the case to the applicable law. The verdict or decision can conclude the litigation process and be enforceable. However, if appropriate, the loser can appeal the decision to a higher court. In some cases, the losing party may have to pay the cost of the lawsuit and the other party's attorney's fee. If you want your day in court with a judge or jury of your peers deciding the outcome, the pursuit of litigation and trial of the case is for you. You may be in a municipal court, state district court, or federal court, depending on the type of dispute you have and where your attorney files your case or where you get sued. We have the characteristics of litigation. It is involuntary. And involuntary, which means a defendant must participate and he has no choice. Formal and structured rules of evidence and procedures. Each party has the opportunity to present its evidence and argument and cross-examine the other side, which means there are procedural safeguards. Then we have also public, which means court proceedings and records are open. The decision is based on the law. Decision is final and binding. Right of appeal exists, and the losing party may pay the cost.